Thank you all for joining us today, and apologies for the minor technical difficulties there. So in today's webinar, we will be getting out our crystal balls to look ahead into data privacy and digital regulation in 2023, and we will be sharing our predictions with you. So first up, we have Mark, who will be talking us through Biden's executive order and the new transatlantic data privacy framework.
Thank you, Eilish. Good day to everyone, I'll say, depending on where you are in the world. We're looking ahead to all kinds of issues for 2023, and probably we start with the one issue that's really kept us all very busy since July of 2020, the whole concept of international data transfers, and particularly the additional paranoia and complexity around transferring personal data to the US since the Schrems II decision. We have clearly spent a lot of time in 2020 wondering whether there's going to be guidance, wondering whether we're going to get new model clauses, and to a degree, as we come to the end of 2022, although many are still working on transfer impact assessments and attaching new model clauses to their existing agreements, we do have a little bit of a status quo in terms of how we can move data under those model clauses and the new model clauses we've been issued. Not simple. The assessments in relation to the US continue to be complicated, but our intent isn't to go there. The one thing we've all been looking at since the Privacy Shield fell in 2020 is, will there be a new Privacy Shield? Can the US and the EU come to some kind of agreement which would replace that shield and give us another alternative mechanism? And I think looking ahead to 2023, we can have some optimism there. I think we will see a new mechanism. As many will be aware, way back in March, there was an announcement from Biden and the Europeans when Biden was on a visit to Poland around some Ukrainian war negotiations, basically announcing a new transatlantic data privacy framework, essentially a replacement to the Privacy Shield, whereby the US will make some additional and new commitments around their signals intelligence and redress that European citizens have within within the US courts, and the way Europe may look to recognise that. And yeah, it's taken a long time. There was talk about having this in October, then there was talk about having this in by the end of the year, then they started talking about Q1, they're now talking about summer of 2023. But I think all of the sort of the balls are in motion, and we will see some kind of change and a new transfer methodology come through in 2023. What's happened? Well, since March of this year, Biden in October introduced a new executive order, an order on enhancing safeguards for the United States signals intelligence activities, essentially some core commitments around the way the US will engage in signals intelligence, effectively their own form of surveillance, placating some of the European concerns and adopting some of those practices to more accommodate the concern raised by the European courts in Schrems II. And then some additional commitments around how there will be redress and a separate and independent court in the US. And this really paves the way, this US change, this paves the way for Europe to then go about its own approvals. And Europe has been in discussions with the US all the way along. The content of that executive order will not have been a surprise. It had been negotiated, and essentially where we are now is the European Commission needs to publish, consider, and then adopt a new adequacy determination, because this transatlantic data privacy framework will be based on adequacy. We expected actually to have seen that draft adequacy decision published by today, really. In fact, in the last couple of weeks, but we've not seen it yet. But this adequacy decision will come out. It'll be circulated, particularly to EDPB, the European Data Protection Board, which will have an opinion. The European Parliament can express a view, adopt a position. It can't it can't derail the process. And then eventually, if it's all agreed, we need to see member states approve and review. But we do have eyes on a process and a process whereby the European Commission may adopt that adequacy determination sometime next year and give us another route to support EU to US data transfers. So quite a lot coming on. There's of course a lot of questions. If I'm in the Privacy Shield, what do I do? Does this give me a leapfrog into the new regime? If if I'm relying on the model clauses, do I pivot? What about my flow downs? And we've got a lot to think about, as well as a new mechanism to adopt and sign up to this transatlantic framework. But it's significant, and what does this mean for all of us? Well, I think it's significant in a number of ways. There was no doubt the Privacy Shield was a more flexible framework. Yes, it had its critics, but it was a simpler way of initiating and protecting for an international data transfer. The fact a party had signed up to the Privacy Shield meant you could rely on that and the adequacy determination around it. There wasn't a need for additional documentation and paperwork, and deals were undoubtedly smoother. So what it means for us, well, vendors in the space will be looking at if those who are still Privacy Shield registered, and yes, there are many out there sort of waiting, well, those Privacy Shield principles, those commitments will remain. There'll be just some small tweaks to those principles as we understand it, and a new way of signing up and making that that commitment to move data. So there may be other vendors who are never Privacy Shield signatories but may want to move to it. So there'll be a decision about whether you want to offer that as an alternative, and whether you're going to go through those extra self-certification processes and to sign up. For those exporting to those with the transatlantic data privacy framework, do they trust it? Is it something you want to use? A number of other decisions, and there'll be a lot of talk in the market. There's already a lot of talk in the market from Max Schrems, from NYOB and others about whether it'll stand, whether it'll be challenged, whether it's sufficient. But we all need to wait and hear what the European Union has to say. Oh, well, sorry, in particular the European Commission, when it issues this adequacy decision. We're perfectly happy to rely on an adequacy decision to transfer data to New Zealand or to Argentina or to Israel as of today. Why wouldn't we be happy to rely on an adequacy decision in relation to a new framework? So a lot to think about there, but timing is going to be everything. I suspect this is something we're going to be grappling with as we move into the summer of 2023. And we'll also be grappling with the uncertainty and the degree to which parties want to invest in the new framework, in particular because of the commitments they need to make, potential changes they need to make to privacy notices, maybe vendor flow downs, maybe contractual changes. The adoption process will not be straightforward. However, the big win is that with this new framework, if it is an adequacy decision, of course, following the EDPB recommendations, we won't need to do TIAs in relation to that transfer, because we can rely on adequacy. That's one massive win, and even around the table here, people are punching the air. That's a big significant win. Even parties not relying on this transatlantic data privacy framework, the changes that Biden has made and the commitments to put in place these new redress mechanisms and the changes to signal intelligence already have a bearing on your TIA, and potentially make some of those TIA assessments when you're looking at a European to US transfer possible. So actually we can start thinking about that today, and a couple of my colleagues have published on that. Richard, who's going to give us some of his thoughts slightly later on in this session, has a blog and comment out on there. So there is a win for everyone, whether or not you're relying on your on the framework, but potentially even more of a win and a significant change in the way we use data. We will be able to have choice, we'll be able to put in alternatives, and for many vendors, given where they've gone in respect of Schrems 2, we'll also be able to have a backup. And I think everyone around the Fieldfisher team, and particularly around this table where we're delivering the webinar today, will realise the importance of being able to pivot and pivot quickly. There's no doubt if you can rely on clauses and the framework, the more sophisticated teams who are looking at ring fencing and protecting themselves ought to be looking at more than one transfer alternative, because we've seen you can be backed into a corner, and we don't want to be backed into a corner again today. So looking ahead to 2023 with my prediction, relatively easy because there's been a lot of noise, and I'm sure there'll be some hurdles and some extra noise to come, but we've got some real developments with this framework and some alternatives and new choices around moving data, whether the UK, whether the Switzerland, whether this has any wider impacts beyond the EU, we'll wait and see. I'm sure that it will, yeah, good news for 2023 on this one. Some slight complexity, but hopefully making all of our lives easier by the summer. And thanks to Eilish, I'll leave you on. So.
Thank you very much, Mark. So next we have Megan, who is going to share her thoughts on the Irish DPC's decision on Meta's EU to US data transfers, which is expected next year.
Thanks, Eilish. Yeah, one more on data transfers from me. So in the wake of the Schrems II decision back in 2020, the Irish data protection regulator, the DPC, initiated an own volition inquiry under the Irish Data Protection Act to consider whether Meta's transfers of European data to the US in reliance on the standard contractual clauses were lawful. Then earlier this year in July, the DPC filed a draft order to halt Meta's transfer of European data to the US. Now that draft was then subject to review by other European data protection authorities under the process which is set out by Article 60 of the GDPR. And those other regulators had 4 weeks to comment or express their objections on the draft. And it was expected that objections would be brought and the DPC would need to submit potentially a new draft for review, which was why the final decision has potentially been delayed. So what's expected in 2023? As Eilish said, the final decision is expected early 2023. If the draft decision is approved, it will prevent Meta transferring data outside of the EU in reliance on the SCCs, and essentially mean Facebook and Instagram services could grind to a halt in the EU. But the question is, what does this mean for others? Would a decision to suspend Meta's data transfers have a wider impact on other US companies' operations in the EU and more generally EU-US data transfers? It's unlikely, we think. The decision largely hinges on the clash between European data protection law and US surveillance law, which, as Mark has explained, the new transatlantic data privacy framework should help to provide a long-term solution, allowing cross-border data transfers between the EU and the US to continue for now.
Great, thank you, Megan. So I'll now talk you through the UK data protection reform. So the Data Protection and Digital Information Bill was introduced in the House of Commons on the 18th of July of this year, and that's supported by the DCMS, that's the Department for Digital, Culture, Media and Sport. In the October Conservative Party conference, Michelle Donnellan, who's now the Secretary of State for DCMS, reiterated the government's intention to move away from the EU GDPR and to replace it with something that was more business and consumer friendly, a British data protection system that was aimed at protecting consumer privacy and keeping data safe while still retaining data adequacy in order to promote businesses trading more freely. The bill tweaks the rules around personal data processing in areas such as consent for online tracking, data for scientific research, public sector data use and sharing, and easing certain regulations for small businesses, as well as changes to the data regulator itself, with the government projecting that this will yield savings for businesses of over £1 billion over the next 10 years. So where is the bill right now? So it passed its first reading earlier in the year, and there's no news currently on a second reading. It was due to have its second reading in Parliament on the 5th of September, but this was cancelled after the announcement of Liz Truss as the new Conservative Party leader and Prime Minister. So the bill hasn't progressed very far in the House of Commons at this stage. The bill's impact assessment states that reform of the DPA 2018 and the UK GDPR is necessary, as the current regime can be complex to interpret and apply, particularly for SMEs. They state that this creates uncertainty and hinders compliance, according to the government. The bill's been criticised by certain groups, including the Open Rights Group, which is a campaign organisation focused on surveillance, privacy and free speech. They state that the bill represents a ministerial power grab, particularly as it grants ministers greater power over the data regulator, the ICO, including setting its priorities, which is concerned that exposes the regulator to political direction. However, Tech UK, the Trade Association for Technology, believes that the bill strikes a sensible balance between reform and upholding high standards of data protection rights, but it could go further in seeking the full benefits of data-driven innovation. The Information Commissioner's Office itself commented that the bill would ensure the regulator's continued operation as a trusted, fair and impartial regulator with the flexibility to target action in respect of the greatest harms. We should note as well that Rishi Sunak, one of his top priorities as a Prime Minister, he noted would be to stabilise the economy. So although there may not be much appetite for widespread data protection reform from that perspective, there is certainly appetite within the Conservative Party more generally to push ahead with such reforms, but it does remain to be seen what sort of format these reforms will ultimately take and the corresponding impact on the UK's adequacy decision from the EU. So moving on to the adequacy decision from June 2021, large volumes of trade rely on the UK having EU adequacy status. It's crucial for businesses, for business as usual operations for UK services with EU customers. Reports state that if EU to UK adequacy was lost, businesses would encounter increased compliance costs estimated to be £1 to £1.6 billion. In February last year, the EU ruled that the UK currently offers an essentially equivalent level of data protection to both the GDPR and the Law Enforcement Directive. However, it said it reserves the right to change its mind if the UK diverges too far from EU law. Further, the UK's adequacy status will be reviewed by the European Commission in 2025, so there's little room for deregulatory manoeuvres, as any changes to the data protection regime that may result in less protection to personal data could impact the UK's adequacy decision, which will have an impact for businesses. Any new legal frameworks for UK data protection that prioritises innovation and flexibility could pose challenges when attempting to reassure the EU that the UK's privacy standards remain aligned and offer an essentially equivalent standard of protection. So on to our prediction. The draft bill did reach a second reading, postponed only due to the uncertainty with the UK government. So now that Rishi Sunak has been appointed as Prime Minister, we expect that the bill will be back on the agenda perhaps early in the new year. However, with a general election only 18 months away in the UK, it's possible that the bill may not progress at all. So we'll have to see about that. In terms of what that means for you, it could result in the creation of multiple data protection regimes that companies will have to comply with, and it could result in the overhaul of internal processes and procedures. That certainly won't promote this free trade of businesses that was clearly envisaged by Michelle Donnellan, so we'll keep an eye on that. Moving on to the online safety bill, staying in the UK. So that was introduced on the 17th of March 2022 and originally proposed by Theresa May in the Online Harms White Paper. The bill survived a total of 4 Prime Ministers and 7 Department Secretaries during this time, and it shifted from an original focus on harms that included online abuse and harassment, and then a move towards child protection, particularly in respect of suicide and self-harm following tragedies such as the death of UK teenager Molly Russell. So what stage is the bill at now? Well, as of this Monday, the 5th of December, it's completed the report stage. So the House of Commons has agreed that the bill will be recommitted to a public bill committee in respect of certain clauses and schedules. So proceedings in the public bill committee on recommittal is expected to conclude on the 15th of December of this year. The inquest into Molly Russell's death concluded in September that social media had been a factor in her death, and the coroner's Prevention of Future Deaths report recommended a series of measures be taken in order to regulate and monitor minors' access to social media content. So following this, the DCMS committed to making edits to the bill before bringing it back to Parliament. Those changes include strengthening child protection elements, such as platforms being required to enforce their age restrictions, and transparency around how minors are age-gated from the platform. The legal but harmful provision was removed. This was criticised by some for violating the rights of adults in order to choose their own legal speech. But the removal has also sparked controversy with some groups, as it's seen as a watering down of the bill. Michelle Donnellan stated that the bill offers a triple shield of protection, as it requires platforms to remove illegal content, remove material that violates their terms and conditions, and gives users control to help them avoid seeing certain types of content. So she believes that this doesn't represent any weakening of the bill. The bill changes also include a provision that makes the encouraging of self-harm a criminal offence, and this was specifically extracted from the legal but harmful provision that was ultimately removed in order to ensure that platforms would be legally bound to remove that content. There were stronger provisions included around the abusing of intimate images and criminalising the sharing of deepfake intimate photos and videos without consent. Finally, there's a new provision under which platforms are required to enable users to opt to see a filtered feed in order to limit their exposure to unpleasant and unwanted content, but that is not necessarily illegal. So moving on to our prediction, with the UK recently agreeing the Digital Services Act and the Digital Markets Act text, and the discussions in the US around the bipartisan Kids Online Safety Act, we can certainly see the direction of travel regarding online content providers. So we think that it's unlikely that this bill will fall away. It certainly looks like we are likely to have online safety legislation in place during 2023, although given the various amendments to the bill that we've already seen as it's passed through the House of Commons, we expect that it could look slightly different to how it looks today when it ultimately does come into force. So what does that mean for you? Well, for companies that fall within the scope of an online content provider, such as social media platforms, online forums, or search engines that host user-generated content, the bill will impose various duties regarding transparency, reporting, user identity verification. So companies that are affected will need to engage with technology that would enable robust age gating and verification. We should note as well that the administrative burden for affected companies could be substantial. In the government's impact assessment for the bill, it estimates that collective transitional costs could sit between 50 and 95 million pounds, with annual costs thereafter estimated to be 290 million. So watch this space. And now we'll move on to Natalie, and she will talk us through which jurisdictions you should be keeping a close eye on during 2023 for data privacy regulation.
Thanks, Eilish. So I won't touch on the UK as Eilish has already covered that, but I can add to the raft of new data protection legislation that's coming our way in 2023. Unfortunately, the UK is not where it stops. So I will try and do a spin through what you can expect in 2023. With the major disclaimer that this may not even be everything, but hopefully this will give you a sense of what to watch and the things that we know, the big changes that we know are coming down the pike. So starting with Australia, in November of this year, the Australian Parliament approved the Privacy Legislation Amendment Bill, which will update Australia's now 34-year-old Privacy Act. The changes will bring the Act closer to a GDPR-like regime in a number of respects. The main headlines are that the amendment introduces new and vastly increased maximum fines for data breaches, and fines under the new legislation can now be imposed up to the higher of 50 million Australian dollars, which is approximately 35 million US dollars. 3 times the value of any benefit that has been derived from the breach, or up to 30% of the company's turnover. The current maximum, just to put that in perspective, is 2.2 million Australian dollars, which is approximately 1.4 million US dollars. The amendment comes after major high-profile data breaches in Australia that gave rise to the exposure of millions of personal data records of Australian citizens. So this was seen as a very necessary amendment. And additionally, other changes introduced by the bill include new investigative powers for the Australian Information Commissioner, who will now be able to require persons or companies to provide information and documents and answer questions, so very much audit right, alongside the power to issue infringement notices for an organisation that fails to comply with those requests. Finally, the bill also clarifies the extraterritorial application of the Act. So it's now quite clear that businesses that carry on business within Australia will be subject to the Privacy Act. There will no longer be a threshold for foreign entities to hold or collect personal information within Australia before the Act applies. The bill's been passed, it's waiting royal assent, after which the changes will come into force, and we can expect that to occur during the early part, I think, of 2023. This is just sort of the first step in a wider review of the now quite aged 1988 Australian Privacy Act. So we're likely to see other amendments introduced in the course of next year, or perhaps beyond that. Next, we turn to India. So there's a little bit of history here because India introduced the Personal Data Protection Bill, which would have overhauled the Indian data privacy rules with a GDPR-like regime back in 2019. But after a number of years going round the legislative process, that bill was withdrawn in August of this year. In November this year, a new bill, the Digital Personal Data Protection Bill, was introduced with quite a similar principle-based regime, including many GDPR-like hallmarks, but in this case is limited to the application of data processing in the digital space. So offline and paper-based processing, would be out of scope. Like the previous bill, the new legislative proposal will have an extraterritorial scope, applying to the processing of data in connection with the offering of goods and services to persons in India. A number of the data subject rights of the previous bill have been dropped, including the right to data portability and the right to be forgotten, but other GDPR-like rights are still included. A key perceived improvement in this new bill is the absence of data localization rules, but instead the new legislation suggests the adoption of data transfer restrictions, quite similar to those under GDPR, with central government required to specify jurisdictions outside of India to which data could be freely transferred. So it feels very similar in many respects to something like the GDPR. And public consultation on this bill is open till December 17th, and so we can expect to see more legislative movement in India in the new year. On to the US. There's a fair amount to say, so I'll keep it high level, but as I'm sure many of you will know, the United States still does not have a federal data privacy framework, in lieu of which we are seeing an increasing patchwork of state-by-state privacy bills and new legislation. And there are a number of updates that we know we can expect in 2023. So for California, the California Privacy Rights Act is going to become effective in January. This is effectively CCPA 2.0. It strictly entered into force in 2020, but becomes operative in January 2023, amending the CCPA with a number of new provisions, including with respect to the establishment of the California Privacy Protection Agency, which will take over the power to enforce the CCPA from the Attorney General. Draft regulations were recently issued, but they've not yet been finalised, making full compliance by January 2023 extremely challenging. And we can expect to see changes potentially to regulations introduced after the effective date. Next is Virginia. They've introduced the Virginia Consumer Data Protection Act, becoming effective also January 2023. It will apply to businesses in Virginia or businesses that produce products or services that are targeted at residents of Virginia. Colorado have introduced the Colorado Privacy Act. This will become effective in July 2023. again applying similarly to organisations that conduct business in Colorado. Connecticut are introducing the Connecticut Act concerning personal data privacy and online monitoring, which will be effective on July 1st, 2023. And Utah are introducing the Utah Consumer Privacy Act, which will become effective at the end of 2023 in December. All of the new data protection legislations in the US states contain consumer rights, require increased transparency around data processing, and introduce key data protection principles, including data minimization, security, and purpose limitation. So a number, again, of hallmarks that we know are reminiscent of GDPR, unfortunately adding to a patchwork of US privacy legislation, which is not all uniform. A brief mention of the new Swiss Data Protection Act that comes into force in September 2023, bringing the Swiss data protection law in line with the GDPR. The current law in Switzerland is modelled on the previous EU Data Protection Directive. I think the main takeaway there is that if you're complying with the GDPR, the Swiss legislation, you'll be in good shape broadly to comply with the Swiss legislation, which is very much mirrored upon it. And finally, just to mention that Canada this year in June introduced Bill C-27 into the legislative process, which, among other things, sets out the Canadian Consumer Privacy Protection Act, or CPPA, which, if passed, will replace the current framework under the Personal Information Protection and Electronic Documents Act, PIDA. The bill is a move in the direction, again, of a more GDPR-like framework, including material fines for non-compliance, private right of action, and codification of the various privacy principles under PIDA. The bill remains in the legislative process, but is likely to receive royal assent in 2023. So our predictions, I think there's a lot of change happening. There's a lot of movement towards something GDPR-like, but it's not uniform. There are going to be a proliferation of new laws and therefore new challenges for organisations that are doing business internationally. What this means for you? Well, it's going to be more important than ever to keep a track on the potentially divergent requirements across these legislative proposals and the new laws that are coming into place. Updating all of your data mapping to understand where your data lives, where it's transferred to, and where it's processed, and to understand which laws you actually need to comply with. And then once that is understood, considering your strategy for complying, whether that be very granular jurisdiction by jurisdiction compliance, the reliance on the GDPR as a gold standard and perhaps only highlighting divergences which are material, focus on your material jurisdictions, the ones in which you feel like you have the biggest risk exposure to new privacy legislation, or perhaps a wait and see approach where you try and see where enforcement is most likely or where you may be most affected. So there are a number of things to think about. A strategy is going to be important if you are a global business trying to juggle compliance with these increasingly complex and divergent regimes.
Great, thank you, Natalie. So next, Richard is going to explore the latest developments within the artificial intelligence space.
Yeah, thank you, Eilish. So artificial intelligence is obviously a huge topic at the moment, and no doubt will continue to be a big topic in 2023, probably more so. I think in terms of notable things over the past year or so around the governance and regulation of AI, I think there are really three things that have been notable. The first is this huge growth in what's often called responsible AI, which is, how are we using AI responsibly, ethically, and respectfully of individuals' fundamental rights. And that's a pretty broad church, but it really considers, should we be using AI in this way? How are we using AI? How are we accountable for using AI? All of those sorts of questions. And what we've seen is many organizations introducing a set of ethical principles or AI principles that they seek to adhere to whenever they are designing or using AI within their organization or within their products. And in some cases, that's also led to organizations setting up ethics committees or panels that would consider specific or high-risk use cases around AI. And related to that, organizations introducing new processes to demonstrate accountability around AI. So documenting how AI is being used and introducing risk assessments where necessary. So this is a developing space, and I think relevant for many different organizations considering the broad application of AI and its increasing ubiquity across many different scenarios. The second notable thing is that we currently still don't have any horizontal or general framework for the regulation of AI. And instead, what we're left with is really a patchwork of different rules that apply to AI. So some of those are existing laws that indirectly regulate AI depending on the use case. So a good example here is the GDPR that regulates the processing of personal data, and that's clearly going to be relevant for many instances where AI is trained, used, deployed, etc. And there might also be laws around non-discrimination in an employment context, things like that, that are going to be relevant when AI is being used and implemented into existing processes. But we've also seen a growth in targeted rules and guidance around AI, so more sectoral and local rules that apply to specific use cases. So they might be in particular regulated industries like finance and healthcare, but we've also seen that local laws either at the state or even city level around particular use cases. So for instance, New York introduced a law around using AI in employment. So what we're left with is really a very complex and wide-reaching patchwork of rules. A lot of them aren't going to be relevant for all, but understanding where those lie and which are relevant for you has been an increasingly difficult task. And then the third thing to note, I think, is the EU AI Act. So this is a landmark piece of legislation that many are watching. It's still at the proposal stage, and it's expected to be another landmark law coming from the EU, and it's really the world's first attempt to introduce a more general framework regulating our use of AI, and it's based on a risk-based approach. I think it's fair to say that we've seen a lot of noise from the EU in terms of digital regulation. That includes laws that have recently passed, like the Digital Markets Act and the Digital Services Act, as well as laws that are still in flux. And at the proposal stage, they include laws like the Data Act and the Data Governance Act. Out of all of those, the AI Act is certainly one to watch and to be aware of. It's expected to possibly be a real milestone in terms of regulating tech in the EU, and may also inspire other jurisdictions as well. The latest development is that on the 6th of December, so very recently, the European Council finalised its position on the text. That's its preferred position, which means that it's ready to now enter negotiations with the European Parliament, and the two different legislative bodies will battle it out and negotiate to determine what the final text of the AI Act will be. So it's still in progress, but further steps have been taken. Looking ahead, so for 2023, what are some of our predictions? Well, what are the prospects that the AI Act will be finalised and passed? I think this one is pretty difficult to say, so maybe I'm going to try and dodge the question slightly. Certainly the AI Act is a legislative priority for the EU, and it is making progress, as I've just mentioned. The European Parliament, on its part, it's expected to finalise its position around March, and then the Council and the Parliament will be negotiating, and that's a process that can take certainly a matter of months, and in some cases can even stretch into years. And we've seen that with the e-privacy regulation that has been going on for a few years now and rattling around. So what are the chances that it'll be finalised? It is feasible that it'll happen next year, but it's by no means certain. And there's certainly still a lot at play and in discussion, not least the actual definition of AI systems that are within scope of the law, what's defined as a high-risk system, how the law will regulate general AI systems. There's so much on the table, and it's a complex and evolving environment. So we may see something substantive next year, or we may simply see further discussion and development. At the same time, in the absence of that general framework, it's certainly going to be the case that we're going to see more and more targeted rules being introduced within particular industries or for particular use cases, and as I mentioned earlier, even at the local level. So there's going to be more rules and further guidance around AI, no doubt about that. But I doubt that we'll see any consensus around what standards should be applied for AI, and we'll have to continue grappling with this patchwork of different rules and standards. Something to mention, though, is that we are expecting NIST to hopefully finalize its AI risk management framework. So this is a proposed voluntary standard for anyone who designs, develops, uses, or evaluates AI technologies. And a lot of people are watching that as an independent and voluntary standard around the use of AI. It's really designed to help developers and users of AI systems better manage AI risks. And those risks could be ones that affect individuals, they could affect organizations or society more broadly. That's still in the works, but it's very likely that that will be finalized next year and will provide possibly the most high-profile framework and set of standards that organizations might want to adhere to. Right, well, with all of that said, what should you be thinking about doing? And I guess some of the takeaways here are similar to what Natalie mentioned earlier with respect to new privacy laws that are coming out. Firstly is just keeping on top of things and staying aware. So with all of these new rules being adopted in an increasingly complex regulatory environment, the key is to identify what are your biggest risks, what are the most relevant jurisdictions and regulators that you need to be aware of, and how are you tracking those to know what might be coming up and what you need to be aware of. And I would mention here one area I think to watch with respect to AI in particular is employment, because we have seen a real regulatory focus around the use of AI in recruitment processes and employee monitoring and other HR and employment related spheres. And that's naturally going to be relevant for all organizations. So certainly something to keep your eye on is how AI is regulated in the employment sphere. And then maybe another key takeaway here is to think about, well, what are you doing today with respect to AI? How are you demonstrating you are responsible and accountable for AI within your organization? And are there any processes that you can consider revamping or revisiting? So that might be, are we being transparent today with our use of AI? How are we able to explain it within the organization or within our product? And are we conducting risk assessments? You know, even if they are not mandatory today, they are likely to be in the future, and therefore considering how your organization approaches and governs AI today is something to think about and put on the agenda for next year.
Great, thank you for that helpful overview, Richard. So Rob, would you like to talk us through California's age-appropriate design code?
Thanks, Eilish. So California passed the Age Appropriate Design Code Act just quite recently, and that comes into force on the 1st of July 2024. The purpose of the code is to protect children in respect of their personal information when they use online services. Now, if you're feeling a sense of deja vu, don't be alarmed. It does very closely mirror the UK Age Appropriate Design Code in both its name and also many of its obligations. The UK code took effect in 2020. So while the California code is very, very similar to the UK code, there are some important differences. For example, unlike the UK code, connected toys and devices are not in scope. Secondly, just as in the UK code, there are obligations to complete data protection impact assessments to identify and mitigate risks, but in California, there are also some very specific deadlines on when these need to be completed. A third important difference is the specific fine regime in California. It's $2,500 for negligent violations and $7,500 for intentional violations, but these are per affected child and so could potentially quickly add up. But to be aware that there is a 90-day cure period, so it might not be quite as bad as you think. So what's our prediction? Well, I think it's going to be an ever greater emphasis, harmonization and enforcement in both the US and in Europe on the protection of children's data. This is a very live issue on both sides of the pond. For example, Ireland have also published their own code called the Fundamentals, and there are several other countries looking at specific rules. And so even though this happens to come into effect in 2024, what does this mean for you in 2023? Well, it can obviously take time to get the necessary preparations underway. So firstly, if you haven't already, just trying to understand whether you're in scope of the CPRA, and also whether you offer services, products and features likely to be accessed by children. Secondly, start that process of completing a DPIA if you haven't already done one under the UK code, or you may need to reflect whether any updates are required to those existing DPIAs for California. And finally, obviously taking some substantive steps to change how you're processing personal data of children, that can take some time. And so really these are actions to be looking at in 2023 already.
Great, thank you, Rob. So thank you all for joining us today. If you have any questions on the content of this webinar, please do reach out to the team here in Silicon Valley. We would absolutely love to help and have a chat. We'll be in touch with you with details of our next webinar. But for now, we're wishing you a happy holidays from everyone here at the Fieldfisher Silicon Valley team and a very happy new year.